Welcome to Sovereign Citizen Legal Encounters. All right, today I have a couple of sovereign citizen clips for you. We have one sovereign citizen in the beginning that's going to double down on everything that she's talking about. In the second clip, the sovereign citizen decided he wanted to give up the script. And I got a third clip for you, which is a bonus. But before we go in, I want to give a shout out to Lone Wolf, who provided the first clip to me. And also check out the link in the description because he has a couple of channels that he's running videos on, and you might want to check them out. Let's go.
Was in the county jail, so I just want to make sure it wasn't that person.
Don't worry, it's something else. I don't know if you have that. Okay. All right. So in the Olympia booth, your name?
Oh, hello.
Yep.
My name is Renee. Renee Gomez is my legal name.
I missed that. Ms. Gomez. Okay. It's Renee Rochelle Gomez?
Yes.
Okay.
Also,
And so Ms.
Alt. I'm sorry, what?
Or no, Ms. Dutch, you've had a chance to talk? Okay. And now I'm being ordered or handed an order to consider under RCW 1077, Ms. Dutch?
Yes, Your Honor. After speaking with Ms. Gomez, I have concerns and I'm requesting a 1077 at this time. I do need to address count 2 and whether there is probable cause given that that particular charge occurred in the city of Tumwater and not the city of Lacey.
I don't know what's happening, but none of that makes sense to me. I didn't talk to anybody. Who are you talking to?
I'm talking to Ms. Dutch. Do you see the attorney with a scarf around her neck?
Yes, but what she was saying doesn't make sense to me. There's nothing.
Okay.
Nothing I had has anything to do with Lacey, and I'm not sure what conversation she's talking about.
City of Olympia. Maybe I misspoke. It's misspoke. It's the City of Olympia. Let me look at that. Ms. Dutch, what you're referring to.
Okay, my name is Renee Gomez, and I'm also known as Renee Christ, Jesus Christ Reborn.
Eh?
And the reason I'm saying this is because on February 18th, I'm here to remind the Thurston County Superior Court that on February 18th at 9 a.m., I attended a hearing whereby I declared a state of emergency, a state of emergency due to a complete state of United States government corruption. I called for a legal citizen's arrest of all of the United States court system, the United States government, and I called for the temporary closure of all U.S. courts, beginning from the Supreme Court all the way down to the lower courts. And so this court hearing is actually illegal because there is a citizen's arrest, a legal citizen's arrest that was not taken seriously by the Thurston County Superior Court, but the Department of Justice, the U.S. Department of Justice is drawing up papers because they realize
Ms.
that
Gomez,
they made a mistake.
let the judge have a moment to read the paperwork.
The judge can speak for herself.
Is she entering into full Karen mode?
And so what I'm saying is that this court hearing is illegal. And so I'm only participating so far as to let you know that you are actually operating illegally. The Department of Justice knows what's going on. So does the U.S. Supreme Court. So does the U.S. Congress, the U.S. military, the FBI, and the CIA. They all know about me, Renee Christ, Jesus Christ Reborn. There has been a massive persecution against me, and so when I have been trying to report crimes of the government through various hearings that I've been to in the last, several months, in regarding to the illegal abduction and illegal restraining order placed upon me because there was an abduction of my children and trafficking of my children involving the Olympia School District, involving the Olympia Police Department. And so here we are at this hearing having to do with the Olympia Police Department, who are my mass rapists.
Eh?
And I don't want to go into the court case whatsoever. What I'm trying to say is that the Department of Justice is drawing up papers because I have called a citizen's arrest on the entire U.S. government. I have called on February 19th.
So, Ms. Gomez, I'm going to interrupt you for a second, and I just need to hear from Ms. Pinkston from the City of Olympia.
This hearing is illegal, and you know this. Nathan
Ms.
Cordercroft.
Pinkston?
Nathan Cordercott should have called this court closed as of February 19th. And all U.S. attorneys are corrupt
Ms.
because of their
Hingston, I see
affiliation
count number
with
2 resisting
with
may
the
have occurred
Mexican army.
in the city of Tumwater when I looked at
Mexican
your
army is
police report
an
filed.
underground illegal
Something else to note?
criminal network in the United States government. And so what I'm saying is that
Your Honor,
all attorneys are practicing illegally right now, including you, a district court judge, district court county commissioner.
So,
You
Ms.
are practicing
Hingston,
illegally,
I
and you
find
know this.
probable cause
And
for
so
count
does the
1,
U.S.
but
Supreme
not
Court.
2. If
You
there's
don't have
something
a
more to
legal
know,
leg
I'd
to
be
stand
happy to
on.
hear.
no, Your Honor,
This is
we'll move to dismiss count.
this is an illegal court case right now happening.
So I'm gonna, unfortunately, it's pretty clear Ms. Gomez is having a tough time, and
You
I
need to hear
find
what I'm
that
saying.
there's
This
a
is
good
an illegal
reason
court
for the
case. I made a
CW
legal citizen's
1077
arrest via a
evaluation,
legal court
and we're
system.
done with Ms. Gomez. We're gonna have another
You're
hearing
ignoring the
in
crimes.
custody
You are
on
literally
May
ignoring the
28th at
crimes.
1:30 for a competency review, and I'm appointing Olympia Public Defense, having found probable cause for count 1, but not count 2.
There was a legal citizen's arrest made on February 19th, 2026 at 9 a.m. In the Thurston County Superior Courts. This is a legal
Ms.
citizen's
Gomez,
arrest.
we're
You
done
need
for
to
today. We're
reference
gonna
this,
see you in a few
and you need
days.
to understand that
If
you're
you've
operating
got an
illegally.
attorney, he'll come
The
talk to
Department
you.
of Justice knows about this, and they're going to tell you about it. You need to contact them.
Somebody better say something to her because I think she's about to go off.
This is wrong, what you're doing. You're ignoring legal issues here. You should not be having a hearing right now, and
So
you know
we're
that.
done with the Olympia booth, and we'll see you in a few days.
Did you hear what I said?
I did.
I want you to understand what I'm saying. I made a
I
legal
do
citizen's
understand
arrest
as
via
best
a
I
court of
can.
law.
We're done in Olympia.
If you're not yelling, you're not a sovereign citizen. Now, ladies and gentlemen, let's get to work.
Well, she's definitely high energy. And we'll see what happens when she comes back if I can catch her, because she definitely have a lot going on. And maybe she does need a competency eval, or maybe she's just playing around with the script. Let me know in the comments. But anyway, we get ready to go to a second hearing where there's a sovereign citizen who actually gave up the script. Now, he's in with an attorney, but you'll find out the backstory about what happened to him and why he decided he wanted to change. Let's go.
This is 54-D01-2507-F6-2107, State of Indiana versus Dylan Ashby. Could you say your name for the record, please?
Dylan Stephen Ashby.
The record should reflect the defendant appears here in person in the custody of the Montgomery County Jail and with counsel John Dreyer. The state appears by Chief Deputy Prosecutor Andrew Salter. The matter is set today for hearing on the recommendation of plea agreement. Is that your understanding of what we're doing here today, sir?
Yes, ma'am, Your Honor.
Before the court can accept a guilty plea from you, the court must be satisfied that you understand the nature of the charges against you, the possible penalties, and your constitutional rights. That your plea of guilty is freely and voluntarily made. There's a factual basis for the plea that you are in fact guilty. It will therefore be necessary that we ask you some questions and take some evidence from you. If at any time you don't understand something that's being said, please interrupt the proceedings so we can clarify matters for you. Do you understand?
Yes, Your Honor.
You can also speak to your attorney at any time. Do you understand?
Yes, Your Honor.
How old are you, sir?
39.
How far did you go in school?
GD.
Do you read, write, and understand English?
Yes, Your Honor.
Do you suffer from any mental illness?
No.
To your knowledge, do you have a history of any mental illness or emotional disability?
No.
Are you today under the influence of any alcohol, drugs, or other intoxicating substances?
No.
As I understand the terms of the plea agreement, you would be pleading guilty to count 1, possession of syringe as a level 6 felony. The remaining counts against you would be dismissed. The agreement on sentencing is you'd receive a sentence of 2 years to the Department of Corrections, suspended except for time served, probation for 24 months upon all other terms and conditions of probation set within the court's discretion. Decisions regarding fines and costs left to the court's discretion. State to make no further recommendation other than acceptance of the plea agreement. Is that your understanding of the terms of your plea?
Yes, Your Honor.
And Mr. Dreyer?
Yes, Your Honor.
And state.
Yes, Your Honor.
In order to convict you of count 1, the state would have to prove beyond a reasonable doubt at trial that on or about July 5th, 2025 in Montgomery County, state of Indiana, one Dylan S. Ashby with intent to violate the Indiana Legend Drug Act under Indiana Code 1642-19 or to commit an offense described in Indiana Code 3548-4 did knowingly possess or have under his control a hypodermic syringe or a needle or an instrument adapted for the use of a legend drug or a controlled substance by injection in a human being. You understand the state would have to prove those elements beyond a reasonable doubt in order to convict you at trial.
Yes.
Count 1 is a level 6 felony. It's punishable by a sentence to the Department of Corrections of not less than 6 months, not more than 2.5 years, with an advisory sentence of 1 year. It also carries with it a maximum fine of $10,000. Do you understand the possible penalties you're facing?
Yes, Your Honor.
You have certain constitutional rights that you carry with you throughout these proceedings. Those are your right to a public and speedy trial by jury. You have the right to be presumed innocent unless and until the state proves you guilty beyond a reasonable doubt to each element of an offense. You have the right to confront and cross-examine the witnesses against you, to see them, hear them, and ask them questions. You have the right to have witnesses appear, testify on your behalf, and to use the court's subpoena power to make them come to court. You have the right against self-incrimination, or what people commonly call your right to remain silent. The fact that you don't testify can never be used against you. In fact, you don't have to call any witnesses or present any evidence whatsoever because the entire burden is on the state. You also have the right to testify in your own defense. Should you choose to exercise that right at trial, you would be subject to cross-examination and your statements could be used against you. You have the right to appeal a conviction to a higher court of law. That would include your right to appeal the terms of any sentencing orders. Do you understand those rights, sir?
Yes, Your Honor.
Do you understand that by offering to plead guilty today, you're waiving those rights or giving them up?
Yes, Your Honor.
You understand that there will not be a trial. The state's not bringing witnesses in here to prove that you're guilty, but that you'll be proving your own guilt by your own sworn testimony.
Yes.
You also have the right, sir, to be represented by an attorney. If you cannot afford an attorney of your own choosing, the court would appoint an attorney to represent you. Do you understand that you have the right to counsel, sir?
Yeah.
I'm sorry?
Yes.
That's a right that you never waive. You don't give that up, even by pleading guilty. And even if you go forward today with your guilty plea, Mr. Dreyer would continue to represent you to the conclusion of these proceedings. Do you understand?
Yes, Your Honor.
Do you understand that the plea agreement is an agreement between you, your attorney, and the state, and that the court is not a party to it?
Yes, Your Honor.
If the court accepts the plea, then the court becomes bound by its terms, just as you are. Should the court reject the plea for any reason, your not guilty plea would be reinstated for you. Today's proceedings would not be a matter of record. Do you understand?
Yes, Your Honor.
Do you understand that in order to determine an appropriate sentence, the court must consider what it calls aggravating and mitigating factors? Aggravating factors are factors which weigh against you, which might make your sentence more harsh or punish you more severely. For example, if you have a prior criminal record, the court would consider that an aggravating factor. Mitigating factors are factors which weigh in your favor, which might make your sentence more lenient. For example, a factor offering to plead guilty might be considered a mitigating factor. Do you understand the difference, sir?
Yes.
Do you understand that the court is required to consider both aggravators and mitigators to determine an appropriate sentence?
Yes.
Do you understand that the court accepts a plea today and enters a judgment of conviction against you if you're ever convicted of crimes in the future? This conviction would serve as an aggravator for future sentencing purposes.
Yes.
In other words, your criminal record follows you. You understand that?
Yes.
Has anyone forced you to plead guilty?
No, ma'am.
Has anyone made any threats against you or anyone else to get you to plead guilty?
No.
Has anyone placed you or anyone else in fear in order to get you to plead guilty?
No.
Has anyone made any promises to you outside the terms of your plea agreement to get you to plead guilty?
No.
Is your plea of guilty today your own free and voluntary act?
Yes.
Are you satisfied with the services Mr. Dreyer has given to you as your attorney?
Yes.
Do you believe he's properly representing you?
Yes.
Is it still your intention to go forward today with your guilty plea?
Yes, Your Honor.
Mr. Dreyer?
Your Honor, Mr. Ashby requests the court withdraw his earlier plea of not guilty to enter the plea we've submitted to the court.
Mr. Ashby, you've heard your attorney's motion. Do you join in that motion?
Yes.
The motion will be granted. How do you plead to count 1 possession of syringe as a level 6 felony pursuant to the terms of your plea? Do you plead guilty or not guilty?
Guilty.
Go step up to the witness stand and raise your right hand if you swear to this evidence from me.
Bill,
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may be seated. Please state your name for the record.
Bill Stephen Ashby.
Thank you. State.
Mr. Ashby, were you born March 26th, 1987?
Yes, sir.
On July 5th, 2025, in Montgomery County, Indiana, did you, with intent to violate the Indiana Legend Drug Act or commit an offense described in Indiana Code 35-48-4, knowingly possess or have under your control a hypodermic syringe or needle or an instrument adapted for the use of a legend drug or controlled substance by injection in a human being?
Yes, sir.
No other questions, John.
no question.
We'll take judicial notice of the affidavit of probable cause. And as I recall, I haven't read it recently, but this incident occurred when the CVS contacted police because you were in the restroom there for an extensive period of time. Were you overdosing in there?
I don't really remember, honestly. I was very intoxicated.
On?
Substances I ordered off the internet that weren't even scheduled. But they probably are now. I'm not really sure.
Why'd you have this syringe with you?
For those substances.
State the substances that they found on his person, are they legend drugs or controlled substances?
Well, as to kratom, I don't know. I would have to look into it. I'm not sure I know. First to, yeah, kratom pills, and then green powder that the defendant indicated was kratom also. I don't know, that'd be a research matter for me.
Well, that's an element of the offense. So the courts will keep the term of the plea agreement under advisement pending further evidence of hearing.
There is case law finding kratom. Let's schedule.
Kratom is a scheduled substance. Yeah.
So do you agree with that?
Yeah.
I'm asking you.
Oh, my question.
I don't have any reason to question that if Mr. Gar's done the research.
All right, we'll take the matter of plea under advisement pending further evidence. Mr. Jar, would you like to go forward? And really my concern is that he's been sitting in our jail probably because he failed to appear at some point.
I was incarcerated.
Sir?
I'm sorry. I'm
Okay.
sorry. I'm sorry. I
This
didn't.
is not a conversation.
It seemed like this judge doesn't play.
That he was on probation for a rather lengthy period of time in a prior case when these charges accrued, or dealing in a Schedule I controlled substance out of Hamilton County. So I'm not sure if he's actually an appropriate candidate for probation. Thus, it's not even clear to me that he has a place to live. So those are the issues that I want to have addressed during sentencing. Mr. Jar?
Are we going forward with sentencing?
Yeah.
Okay.
I'm just saying the plea under advisement so we can get that information clarified today.
Dylan, you've read the record check from probation, correct?
Yeah. Yes, sir.
And was it accurate?
Yes, sir.
And we've discussed probation in this county, correct?
Yes, sir.
And I've told you that the judge is well known for being quite strict with probation. You understand, right?
Yes, sir.
And you understand that possessing any illegal substances for whatever reason, if you're on probation, is forbidden, right?
Yes, sir.
And you're gonna give your probation your top priority, correct?
Yes, sir.
Were there any corrections or errors in the report?
I did successfully complete community corrections as far as work release and house arrest goes on that felony. I just violated the last 4 months of probation for THC. Did almost all 2 years of probation. I just violated the very end. And the D felony, I did successfully complete house arrest and probation on. And this was a relapse for me. Based on some stressful experience.
So you're saying the Hamilton County B felony with which you were charged, you got down to the home stretch and then you tested positive for marijuana?
Yes, sir.
You understand that when you're on probation in this county, even though you can buy marijuana products or CBD products at a lot of these gas stations, you can't be in possession or use them. You understand that, Dylan?
Yes, sir.
Anything else you want to say to the court?
And in the free world, I do a lot of ministry, and I have a history of drug abuse and drug addiction, but I've been clean for quite some time, only using over-the-counter products. For various different reasons, and this was a relapse based on trauma that I was experiencing. I've been through a lot the last 5 years. Been through a divorce. I got stuck in a cult in Kentucky. I have a lot of traumatic experience, so I was just any stress that came my way, and I was living off the grid, and that's why this happened. I didn't know what to do with myself because I needed a place to live. I needed a normal job. I needed an ID. I haven't had an ID. I'm ready to be back as a normal citizen. and have ID and live over the table. And that's why this all happened. It's just a ticking time bomb, basically.
You understand that probation, one of their jobs is to help you in your effort to rehabilitate yourself, but you have to do what they tell you. You understand that, right?
Yes, sir. Yeah.
Nothing further.
Steve?
I don't have any question.
Where are you gonna live, Mr. Ashby?
I don't have an address at the current time, but it's only temporary. I got some ideas of where to live. I got some people I can call. There's homeless shelters in nearby cities if I can't find it immediately.
So I'm looking at your substance abuse questionnaire. And I printed this page because I'm having trouble reading it.
Yeah, I had those super awful bendable pens that I couldn't write with as well.
Super rough.
Yeah, the gel pens.
Under the cannabis section, you say frequency of use, you say regular, holy sacrament for something. It's in the Bible. Something else, holy something, Hebrew something. I can't read what it says.
I'm a Rastafarian, and I'm just answering this honestly. It's not a challenge or anything, but cannabis is specifically mentioned in the Bible in the Hebrew manuscript 70 times, and the Hebrew for it's cannabis. That's what I was saying. That's why I have regular use of cannabis. The struggle I have struggles with is opiates, and that's what I need treatment for.
What's the bottom part say?
It's about my opiate.
I understand that it's about opiates, but I'm having trouble reading it. All I can read is opiates help me work 16 hours a day if need be. Then
I lack natural endorphin production. Endorphin is an opiate that the brain makes that is stronger than morphine. Endorphin is responsible for overall contentment and well-being, gut health, etc. Even cheese has endorphin-like compounds called K-morphin. I will see a doctor about this and get on Suboxone if necessary.
What's the last sentence say?
It says Indiana law, because in the Indiana law seems to be partial against herbal medicines like kratom, poppy. I was just answering very honestly.
Sure. So you don't have any place to go when you get out of jail?
I do have several ideas. I just don't have a phone to access the people I need to call to get those addresses. But also there's LTHC and other homeless shelters in Lafayette. I have places that I'm going to go. I'm not just going to walk around the streets here.
Well, you have to report an address to probation. And if you're homeless, you have to report to them every day where you're going to be staying. Do you have the means to do that?
Yes, ma'am.
How's that?
I have a phone ready at the storage unit my family put in there for me. They bought me a phone and clothes and shoes and put some money in there for me. Just taking it one day at a time right now because I don't have a way to contact all the people I know. I don't have all the phone numbers memorized.
So when did you get released from DOC?
April 13th.
That's when you got brought to our jail?
Yes, ma'am.
When were you last employed?
Right before I got locked up, I was doing under the table work for people in this community. I volunteered at the church, which my uncle's the pastor of. He's sitting in the pews over there. All kinds of different landscaping and tree work and farm work. I don't really have a specific place. It's just different people I worked for in the church and the Methodist church.
Do you understand that a term of your probation in this court will be a requirement of probation, full-time probation, or full-time employment at a job where you get a W-2 or a 1099 and a pay stub?
Yes, ma'am. I'm excited to do that. I'm excited to be over the table and live like a normal citizen.
So why have you not been doing that if it's so important to you?
Because I was living off grid and I believed in sovereign ideology, and I'm ready to be done with that.
Maybe it took him a while to find out the sovereign movement wasn't good for him, but at least he's coming out of it.
A lot of different religious reasons that was the case. And it was just getting harder and harder after COVID to live like that because everything just seemed to get worse and worse after COVID. And finding under the table work, it just seemed more impossible to find.
No, thanks.
Nothing else, Sherman.
An argument to make, sir, and in support of your plea agreement, the court has not yet accepted it. Talking to your attorney.
Well, Your Honor, as mentioned earlier, in speaking with Mr. Miller in negotiating this, there were discussions that Creighton is on the list of schedules, and I found a case in Westlaw. I don't have it printed with me. And talking to Mr. Ashby, he was willing to save the court, the county, and people of the county and the litigators the time and effort and expense of the litigation. He's been extremely frank, not that frankness has levels, but Dylan doesn't mess around. He tells the truth. I don't know that lying is in his nature. Unfortunately, he got himself in with various crowds, as he's discussed, various viewpoints that have led him astray. And when he says that he's excited to have a regular job and that he's tired of living off the grid, I think what he's really talking about is living in a subculture. And it's not like he's going to be Mr. Tom Q Public in the future, but he's going to live totally legit. I believe that when he tells me. I have stressed to him, his Rastafarian background and the issue about not being able to use any CBD stuff. And I've talked to him about the how the court is well known for dealing with probation violations, and he totally accepts them and is willing to go on probation and abide by those terms.
State. Do you have any argument in support of theory? Not a sentencing argument, but an argument in support of the.
Well, yes, Your Honor. This is, this is an offense that involves possession. I understand it's kind of the phrase victimless crime is kind of a loaded expression, but this really does not implicate public safety. Mr. Ashby said that he has a plan for succeeding on probation. And I don't believe that there's any benefit to just keeping him in jail and avoiding putting him on probation by, okay, we're gonna hold for a longer period of time because we don't think we can do probation. I don't see the benefit in that. We might as well let him out, put him on probation, and if he if he is not able to keep probation apprised of his address and so forth, then there's time to put a warrant out for him and do something else. But I don't see any benefit to rejecting the plea, Your Honor.
That was a solid argument. We'll find that Dylan Ashby is a male person, presently 39 years of age, having a date of birth March 26, 1987, that he understands the nature of the charges against him, the possible penalties, and his constitutional rights. That his plea of guilty is freely and voluntarily made. There's a factual basis for the plea that he is in fact guilty of count 1, possession of syringe, a level 6 felony. The court accepts the plea agreement and enters judgment of conviction accordingly. In doing so, the court has taken into account the content of the pre-sentence records check. And Mr. Ashby, even though you said, I successfully completed, back in 2007, you were sentenced for forgery, sentenced to probation, violated. They filed 2 violations against you. Your suspended sentence was revoked and you were ordered to home detention. And then you were granted a modification and probation was terminated. So you did violate, and then you eventually finished it. In 2009, then, when you were sentenced for this dealing offense, you're given a sentence of 10 years with credit for time served and the remaining balance on house arrest, 4 years suspended, probation for 2 years. Then 2 years later, they file a violation, and then a community corrections violation. You were found in violation, ordered to serve a year in DOC, and then moved to work release, and then home detention. And then in 2014, there was a violation filed, and it was pending, it looks like, for 11 years. There was a warrant outstanding for you for 11 years.
Well, sovereign citizens are known to drag their case out for years.
So that's my concern. And then when they finally attached you on the warrant was after these charges were filed. So that's my concern. So I hope that you are done with living off the grid and whatever you've been doing, because that's just not gonna work with this probation, I assure you. You're obviously very intelligent, so you need to use that to your benefit instead of using it to avoid responsibility for your actions.
Thank you, Your Honor, you're right.
For having accepted the plea agreement will sentence you pursuant to its terms, you may step down so you can have a seat that'll wait for your turn. You will be sentenced on count 1 to 2 years in the Department of Corrections. That'll be suspended except for the time that you served. We've calculated your credit time at 33 actual days. That's the first 2 days that you served at the time of your arrest, and that you've been in custody for 31 days, it looks like now, for a total of 33 actual days or 66 credit days. The balance will be suspended. You'll be placed on probation for 2 years on the following terms and conditions. You shall not violate the law. You shall notify probation of any arrest within 72 hours. You shall report to and cooperate with your probation officer as directed. You shall continue to report to probation until you are relieved from doing so by the court, even if a modification or revocation is pending. It is at all times your responsibility to maintain contact with probation. You shall provide your address and telephone number to probation. You shall not change your residence or your telephone number without notifying probation in advance. You shall maintain employment. Again, that means at a job where you get a W-2 and either a W-2 or a 1099 and a pay stub. You shall notify probation of any change in employment. If you're unemployed, you shall actively seek employment. For any week that you're not employed at least 20 hours per week, you shall donate 20 hours of community service. So it's to your benefit to get employed sooner rather than later. You shall obtain a written travel permit from probation before leaving the state, and you shall sign a waiver of extradition. You shall allow probation access to your residence at all times. You shall sign a Fourth Amendment waiver to allow for the search of your person or your property. You are specifically advised that probation, law enforcement, or community corrections may search your person or your property at any time without reasonable suspicion or probable cause. So if they want to search you, they can do so. Do you understand?
Yes.
You shall not consume or possess any controlled substance without a current valid prescription, nor any synthetic cannabinoids, which is spice, CBD oil, hemp product, or any other designer drugs. That includes Delta 8, Delta 9, Delta whatever number comes after it. You can get it in most gas stations, but you can neither consume nor possess it while on probation. You shall submit to and pay for alcohol and drug tests of any kind whenever requested by probation, law enforcement, or community corrections. By signing your terms, you are specifically waiving any objection to the admissibility of those test results at a revocation hearing. You shall pay probation user fees. The initial fee is $100. The administrative fee is $100. The monthly fee is $30. The court will not fine you via court cost of $189, a public defender reimbursement fee of $200, and a drug interdiction fee of $200. You shall set up a written budget for the payment of all fees, fines, court costs, and program costs, all of which must be paid prior to being discharged from probation. You shall pay them at a rate of not less than $65 per month. It's the only way you'll get them paid off the tech. You shall not drink or possess any alcoholic beverages. You shall not enter a liquor store or a bar. You shall not possess any firearms, ammunition, or dangerous weapons. You shall sign the vicious and aggressive animal policy and abide by its terms. You shall submit your DNA to law enforcement within 7 days. You shall follow all directives of the Montgomery County Probation Department, and you are ordered to go directly to probation upon your release from jail. Check in and get started with them today. You shall complete a substance abuse evaluation. You shall successfully complete all education and treatment recommendations made by probation, pay all the costs when they become due, and authorize the release of information to probation and the court. You shall complete mental health counseling as probation may direct and authorize release of information to probation and the court. You shall perform 80 hours of community service, rate of not less than 5 hours per month. That's as a direct result of your prior criminal record. You shall successfully complete MRT and any other program as probation may direct. You shall attend at least 3 self-help meetings per week, obtain a sponsor, and verify your attendance. A lot of things will qualify for that. So AA, NA obviously will qualify. Attending church, celebrate redemption, celebrate recovery, meeting with a mentor, meeting with a sponsor. So talk to your probation officer about what that will accept. Do you have questions, sir?
No, ma'am.
Can you abide by those terms?
Yes.
If you should violate, and the court's not saying that you will, because I sincerely hope that that doesn't occur. But should that happen, the state can file a petition to revoke or modify your probation up to 1 year after discharge or up to 45 days after learning of a violation. Do you understand?
Yes, Your Honor.
The remaining counts and charges against you again will be dismissed. Mr. Dyer's appearance will be withdrawn at the conclusion of these proceedings. Good luck to you, sir. That is all for today.
What was the credit, Your Honor?
66 days, I think, 33 actual.
Okay.
This case runs consecutive to the Hamilton County case. All right, that's all. Thanks. Have a good weekend, Mr. Sutton.
Thank you, Your Honor. See you, John. See you.
Well, hopefully when he gets out, he'll start over and he won't go back to the sovereign movement ever again. But anyway, I have one more hearing for you. I'm just going to let you watch it. It's in Thurston Court, so you should already know what's going to happen. Let's go.
Hi, in the Olympia booth, your name?
What?
What's your name? What's your name?
My legal name is Lillian Thompson.
Okay. It's Thompson. So Lillian Joy Thompson?
That's my legal name, yep.
Okay. What's your date of birth?
February 21st, 2003.
Okay. All right. So we're here about another charge, a criminal trespass from yesterday. And I'm going to turn to Ms. Dutch.
Thank you, Your Honor. This is 2026397. We will waive further arraignment, stipulate to probable cause for purposes of today's hearing, enter a plea of not guilty, and request a court-appointed attorney. Ms. Thompson still qualifies for public assistance and has Attorney Hofstad assigned on her pending pretrial cases, which are set for June 9th.
Set for June 9th? What's the date?
Yep, you got some other court dates set on June 9th.
I'm sorry, I'm looking at the date. It says it's
Well, here, let me talk to you about all that in order. We'll get back to that. So, Ms. Thompson, on this allegation from the City of Olympia on criminal trespass from yesterday, I'm going to enter a plea of not guilty, keeps all your rights in play. And then I'm going to appoint an attorney. I think Mr. Hofstad, he's already representing you on other cases. He'll represent you on this. And then as before, I'm going to hear from the prosecutor and from Ms. Dutch about release conditions. And Ms. Finkston on behalf of the city.
Thank you, Your Honor. At this point, we've been seeing Ms. Thompson every few days for new law violation allegations. She was just here either earlier this week or, I think it was on Monday, actually. She was here for another criminal trespass. Before that, she has that other pending case with the assault and obstruction disorderly. At that time on Monday, we talked to her about that, and I found out I think she's from Idaho and doesn't have any resources here. But we also talked about what does that mean, and I think that the court also gave her some information about resources. So to have her come back so quickly is obviously disappointing. At this time, I do have concerns that she will just continue to violate the law. Every few days, we're seeing her and she gets PR'd. And now we have 3 active cases from a week's span of time. So at this point, I am asking for bail. I think it's appropriate. On the newest one, I'm asking for $500. And then I'm also asking to revoke release on the 2 pending matters. On 384, I would ask for another $500, and on 370 for $1,000 for a total of $2,000. She's already been trespassed from the location she was arrested last night at, but for the court to reiterate that she's not allowed to go to the Olympia Mall.
What?
Ms. Dutch?
Your Honor, Ms. Thompson is unfamiliar with this area, and this could be a situation where she was confusing the Capitol Mall with the Tacoma Mall. There was no intentional law violation on her part. I do note she has no FTA history. It's a non-violent charge. She has no convictions at this time. So given the presumption of release, we would ask for a PR release and keep that June 9th hearing.
We're going to keep the June 9th hearing. Ms. Thompson, I'm going to have you post some bond. I'm just going to place it on this one. 500 cash or bond needs to be posted because we've released you, rearrest, and at the same spot. So
can I talk?
So you have to post 500 cash or bond on this one. I'm going to release you on the other 2.
So
in order to be fully released,
500 cash or bond,
right.
but can I talk? Can I legally talk? Yes.
Well,
not about
I would want Ms. Dutch to give you some advice.
Okay.
I don't want you to talk about the case itself. We're being recorded, and I don't want anything you say to potentially be used against you. But if you have a question about release, we can address that.
I have a question about release.
Okay.
Will I be released today?
If you post 500 cash or bond, you will.
If with the impost,
You have to post 500 cash or bond to be
I
released.
don't have 500 cash or bond because guess what? I'm gonna talk. Excuse me, but I'm gonna talk.
Don't talk about the case itself.
I don't need to take your advice. I am a free human.
Is she going sovereign on us?
Okay,
So
I'm going
we're
to
finished with our hearing, and we're going to be
Okay, I
back
don't
on
have
June 9th.
$500
Mr.
to
Hofstad
give
and you will
Can you
talk in the
at least give
meantime.
it to me and I take it?
If you post, don't go back to the Capitol Mall or their property, as we told you
I
before.
thought
Don't violate
the
the law.
Olympia Mall is where I went, which is different from the Tacoma Mall.
Right, you were at the Capitol Mall in Olympia, and that was where you weren't supposed to be, is what the allegation.
I thought that Olympia and Tacoma
Ms. Thompson, please don't talk about the case.
there with a guy.
Don't
We're
talk
done
about
with
the
the
bus.
Olympia
So
booth,
do I have
and
to
we can
give
take
the
Ms. Thompson back.
$500
Thank you.
or
I
can
am
I
protecting
leave?
saying too much.
Yeah, I won. Yeah.
Your Honor, can we move this up sooner than June 9th, given that she won't be able to post bail?
Leave it to Mr. Hofstad to make that
Yes.
decision, and he can always ask us within 24 hours. Just let us know if he needs an earlier hearing. So I'm going to leave that to Mr. Hofstad to let us know if there's something to do. I'm sure he will.
Well, that was the bonus clip for you at the end. As a matter of fact, Lone Wolf gave me that one too. So anyway, I hope you enjoy all the videos. Give it a thumbs up if you did. Leave a comment, and I'll see you around on the next one.
Courtroom, motor respect. Judge looked calm, let her talk for a minute, but the whole hearing turned when she doubled down in it. Said the whole system should have been shut down. Talking citizens arrest while she stared around. Said attorneys practicing law was a crime. Tried to stop the hearing almost every line. Talking sovereignty, talking hidden truth. Judge trying hard just to get through the proof. Court kept moving, she kept pushing back. Every single answer turned into another attack. This hearing illegal, she said with pride. Wouldn't let the courtroom narrative slide. Everybody watching knew where this goes. Once the script starts rolling, it only overloads. Court is illegal, that's what she claimed. Judge kept moving, nothing really changed. She doubled down, wouldn't slow it down. Sovereign citizen script echoing through the courtroom now. Judge mentioned competency, tension got thick. Arguments spinning and the pace got quick. Every interruption made the room get colder, but she kept talking louder, getting bolder. No backing down, no changing lanes. Still convinced the court couldn't hold the reins. Meanwhile, another defendant in another place said he was tired of living that way. One walk deeper into the fight.